And now it's time for another Caselaw update. Today we're diving into DDR Weiner Limited versus Oventive USA Inc., a recent decision out of the Fifth Circuit Court of Appeals that gets into prior period adjustments on royalties and the doctrine of equitable recoupment. Let's set the scene. This update centers around a royalty dispute on several tracts of land in Karnes County, Texas. Oventive was operating oil and gas wells on land owned by the Richters and was regularly making royalty payments to the Richters. In 2017, the Richters transferred their mineral interest to two entities they owned and controlled for estate planning purposes. The two entities were DDR Weiner and DDR Williams, who became successor lessors and started receiving royalty payments. Before the transfer happened, Oventive made an error. In September 2016, they mistakenly adjusted the gas flow on several properties, including the one in question. This error led to some royalty owners being underpaid and others, like the Richters, being overpaid. Oventive didn't catch this mistake until January 2018, after the transfer to the Richters' estate planning entities had already occurred. When Oventive realized the mistake, they did what's known in the industry as a prior period adjustment, which we've talked about on this podcast before. That's basically an accounting mechanism where past overpayments or underpayments are corrected by adjusting current or future payments. In this case, Oventive withheld more than $600,000 in royalties from DDR Weiner and DDR Williams to recoup what was overpaid to the Richters. DDR Weiner and DDR Williams sued. They alleged breach of contract, conversion, and violations of the Texas Natural Resources Code. The district court sided with Oventive and granted summary judgment in its favor. On appeal, the Fifth Circuit affirmed the decision, but on slightly different grounds. The Fifth Circuit relied heavily on the doctrine of equitable recoupment. Recoupment is a common law doctrine, expressly adopted by Texas, that states that if two parties are involved in the same transaction and one overpays the other, they can offset that payment by deducting it from future obligations, as long as everything stems from the same transaction. Here, the Fifth Circuit found that both conditions for equitable recoupment were met. One, there was an overpayment to the Richters, and two, the overpayment and the subsequent withholding arose from a single transaction, namely, the same ongoing lease agreement. The plaintiffs, DDR Weiner and DDR Williams, tried to assert that Oventive's actions were improper because they, not the Richters, were being docked their payments. However, the court emphasized that the Richters control both DDR Weiner and DDR Williams. So essentially, the same people who were overpaid were now trying to collect again under different legal names. The court pointed out that Oventive did not profit from the error. In fact, it was trying to fix a mistake. The only parties unjustly enriched by the situation were the Richters, who received too much money, first as individuals and now potentially through their LLCs. It's important to note that this case did not involve a transfer to a third party, and given the reasoning the court provided for its decision, things may have turned out differently if it had. That's all for this Caselaw update. We hope you learned something new. Thanks for listening. I'd like to thank Kanika Drakshuram, a law clerk in our Houston office, for her help on this update.